Hey guys, welcome back to today's video. I've got a short one for you today because we're dealing with an absolute idiot in court who just can't seem to stay out of his own way. But before we get into that, I want to give you a little sneak peek at what's coming this week. First up, we've got Judge Tammy, who you all loved in the last video, doing what she does best, shutting down another sovereign citizen completely and making it painfully clear who's really in charge. And trust me, this week's lineup is going to be full of chaos, courtroom meltdowns, and people making the absolute worst decisions possible. So make sure you stick around for every second.
If I enter like an oral motion of dismissal based on constitutional grounds, are you standing on your constitutional oath?
I'm not sure what that is.
In regards to the right to travel under the 14th Amendment.
Okay, so that's not actually in the Constitution.
I just wanted to point out to the court that automobiles hadn't been invented when the 14th Amendment was ratified.
Then we have Judge Perkins stepping in and calmly taking control of the room, explaining in clear and simple terms exactly why the court does, in fact, have jurisdiction. There's no arguing, no back and forth, just a steady breakdown of the law and how it applies to this case. He doesn't raise his voice or get emotional, but the message lands hard. This is his courtroom. These are established legal principles, and jurisdiction is not up for debate. It's one of those moments where the explanation sounds polite on the surface, but the authority behind it makes it unmistakably clear that the argument is over.
Mr. Gray, are you trying to get a driver's license?
Your Honor, I'm here by special appearance.
I knew that was coming. Let's just talk a little real simple, basic stuff. Are you trying to say that you can just run red lights, you can just speed, you can just do what you want to do on the roads without any repercussions at all?
Your Honor, is this a court of record? I'm sorry, is this a court of record?
As far as I checked, it was. Mr. Glenn?
Yes, it is, sir.
Wrap up the week. We're left with an out of control, clearly delusional Karen who genuinely believes she can threaten the court into backing down. She openly talks about suing the very system prosecuting her, as if that alone will make the charges disappear. It's chaotic, it's detached from reality, and it perfectly captures the moment where confidence turns into pure legal fantasy.
So I will be countersuing Romulus, I guess it would be Van Buren. And if the court proceeds with this, I will be also bringing the malicious prosecution against this court as well, because these are erroneous charges and they're retaliatory, which is a violation of my freedom of speech. It's a violation of my right to due process. So if this does not get dropped today and it moves forward, I will be filing under color of law lawsuits against Van Buren and this court for violation of rights under federal question jurisdiction. So I just don't think it would be a good use of the court's time or resources to continue this malicious prosecution. They completely ignored my evidence. There was sexual discrimination against me because I was a woman. It would really be a waste of the court's time.
We've got a crazy week ahead of us, with no shortage of courtroom chaos, wild arguments, and moments that completely spiral out of control. There's going to be a lot to break down, a lot of reality checks, and a lot of people learning the hard way how the court system actually works. So get settled, stay with us, because things are about to get interesting. With that said, let's begin.
Okay, we're on the record in McNamara versus Sylvester, case number 2018299. The record should reflect Mr. Sylvester has appeared today by Zoom video. We also have Mr. Brzezinski present on behalf of friend of the court. This is set for a show cause hearing today regarding support. And Mr. Brzezinski, can you give me an update on this case?
Yes, Your Honor. This hearing was adjourned from February 6th for the defendant to pay $200 plus stay in communication with the friend of the court if he did not have that ability to pay. He has a support obligation of $363. This is now, I believe, the sixth show cause hearing since June 22nd of 2022. The last payment was August of 2022 at $400, so most of these hearings have now resulted in payment. Multiple times the defendant has been ordered to provide job searches to a friend of the court, which he's done, but it has not resulted in him gaining employment or making any payments. So the friend of the court would ask if he does not have employment or any income, that he provide proof of that, whether it be unpaid bills, rent, proof that he's going to the interviews, just verification of all those details to prove that he truly does not have an ability to pay.
Well, I can tell you that my phones are currently shut off with a past due balance of almost $900, if that counts for anything. And I'm behind on my mortgage. That's $606 a month. currently don't get a electric and gas bill because something's wrong with consumers. But I can tell you that we're behind in that too. There's only one income in this house, and there is a baby due next month as well. There should be a payment made. I just filed my taxes. I received my state taxes. I know you guys do with income withholding on that. So you guys should be getting a payment from my taxes. I was supposed to get $600 and some change, and I only received $238 back. So there should be a decent payment going to you guys out of my taxes.
Mr. Brzezinski, if the court proceeds with contempt proceedings at some point, would this be a first or subsequent finding?
I believe this would be a first finding of contempt, Your Honor.
Okay. All right. So I'm going to set this for a contempt hearing in April. Mr. Sylvester, there's a couple of things that you need to do under the law. And number one is to make your payments, of course.
Okay, well, I have absolutely zero.
Can you listen to me for a second?
No, I'm listening. You guys tell me this every fucking time.
I always tell people it's never a good idea to show up to court completely detached from reality. But nobody ever wants to hear that advice. So let's slow this down and actually break apart what's happening here. Because every word out of his mouth is doing real damage to his own case. If he had taken a moment to actually listen to the friend of the court, he would have heard something important. Yes, he's behind on child support, but that wasn't the end of the story. The court officer went out of his way to point out that there was documented evidence showing he's been actively trying to find employment. Even though he hasn't landed a job yet, the fact that he's making the effort matters. Courts care about intent. An effort goes a long way when someone is genuinely trying to get back on track. But with one reckless, unhinged comment, he manages to undo all of that goodwill in seconds. And the worst part is, he's not even finished yet.
First of all, don't use that kind of language. You're in a court.
Okay, what are you going to do?
What am I going to do?
I don't come up there.
I'm going to hold you in contempt. I'm going to issue a bench warrant for you to be arrested. Do you want that to happen?
No, but you guys tell me this every time. I have 92 applications out on fucking Indeed right now. I can't help that I can't.
I get that you're frustrated, but this is now the second time you've completely lost control and said something you can't take back. The patience in the room is gone, and the judge is clearly reaching the end of his rope. You're about to get one final warning, and at this point, it would be a really good idea to stop talking, refocus, and actually listen to what the judge is telling you, because whatever comes next is entirely on you.
Mr. Sylvester, based on your language, I've already warned you one time. If you use that language again, I will hold you in contempt.
Okay, well, as I was saying, I cannot help that I can't get a job. Okay, so I've had some places call me back, but it doesn't get me anywhere. I've had 2 interviews out of all of my applications. We've got one vehicle, one income. My insurance is actually almost expired because I can't pay that either. I don't know how I'm supposed to make payments when I don't have an income. I don't know how you want me to prove it, but I'll prove it.
Are you done?
Okay, I see where this is going.
Are you going to listen, or are you?
Oh, I'm listening. I'm going to get my shit transferred.
Before you end up in jail for contempt, because the judge has already given you more than enough warnings to rein yourself in. Instead of taking the hint, you doubled down, lost your composure, and decided to go completely off the rails. Somewhere along the way, you convinced yourself that being on Zoom made you untouchable. Like courtroom rules suddenly didn't apply, and that's where everything really starts to fall apart. The frustrating part is that all of this outrage is for nothing. Yes, you are behind on child support, and that's a fact the court cannot ignore. Because of that, the court is required to hold a contempt hearing. But here's the part you keep missing. A contempt hearing is not a finding of guilt. It's simply a chance for you to present evidence, explain your situation, and show your efforts in a way that's logical, coherent, and not dripping with disrespect. Everything you tried to say today could have mattered. If you had just said it the right way,
All right, you just used more inappropriate language, so I'm going to, based on your conduct here at this hearing today, I'm going to find you in contempt. I'm going to order that you serve 30 days in the Otsego County Jail for contempt in the view of the court. This is a summary proceeding, and that's based on your conduct here in front of the court.
Speak to a lawyer.
I'm going to issue a bench warrant for your arrest. You'll serve your 30 days here once you're arrested and brought before the court. I'm also going to set this for a contempt hearing in April. If you aren't employed and you can't make payments, you need to provide proof of that to the friend.
Okay,
of the
how?
court.
You guys don't tell me any way how.
Or bring proof of that to the hearing in April.
Okay, you guys want proof, but you guys right here, this is exactly what I'm.
Okay, I'm muting Mr. Sylvester now because I need to be able to make a record and he's talking over me.
Because you guys don't give me a chance.
I'm going to, I gave Mr.
Hey, babe.
I know, you depend on me, but at this point, I've proven I'm too reckless to stay out of jail. And don't get me wrong, there's a dark part of me that can't look away when someone insists on smashing headfirst into consequences. They were warned about a dozen times. Watching someone actively sabotage themselves while insisting they're the smartest person in the room is almost impressive in its own way. But the part that actually sucks is that he's not the only one who's going to feel this. Innocent people are about to pay the price for his tantrums, his ego, and his complete inability to control himself. And disappearing on the judge like this, acting like avoidance is some kind of strategy, isn't helping him or his family at all. It's just another bad decision stacked on top of an already collapsing pile.
Mr. Sylvester, I've given you more than an adequate opportunity to talk here today. And at some point you have to listen and you're not doing that. So I'm muting you because I need to make a record. So if you don't provide that proof to the friend of the court at the hearing in April or bring it or provide it to the court for the hearing in April, then the court will issue or proceed with contempt proceedings, and you could be subject to a contempt penalty of up to 45 additional days. So Mr. Brzezinski, if you can set that for a hearing for contempt in April, I'm going to issue a bench warrant for the court's finding of direct contempt here on the record today, which is a separate issue that you don't need to deal with, Mr. Brzezinski.
Okay, thank you, Your Honor. I will do that.
That wraps up today's video. Like I said, this one was short and sweet. Just a little warm-up to get you ready for the absolutely wild week ahead. And trust me, you are not going to want to miss a single second of what's coming up. So if you enjoyed the video, hit that like button. If it wasn't your vibe, hit dislike. But either way, make sure you leave a comment down below because I want to hear what you think. And don't forget to subscribe with notifications turned on so you never miss any of my content. I'm Team Saju Shah, keeping it real, and I'm out.